A young couple went to India to celebrate birthday of their son. The husband, a blood clot went to his heart, so he passed away without a will. She was so distressed, saying, I don't have any will for my husband. I don't know what he has. He has a business, but I don't know what forms part of the business, or I don't know how to get his body back in Melbourne if there is not enough money in the estate to cover the liabilities, or the surviving partner does not have the borrowing capacity. Then you're losing an asset they have to sell so they can repay the bank first and then find themselves without a roof over their head. You have no idea what sort of mental peace and clarity you bring to your family members that brings them a great peace of mind that you can't put money on.
Hi everyone, and welcome to another episode of Levelup with Priyanka Shah. With the holiday season around the corner, I'm sure most of us are so excited about taking off overseas, booking trips, planning gifts for everyone, and making sure that every detail is planned out as much as possible to make our memories beautiful. But the one thing that we often forget about is making sure that our wills and powers of attorney are up to date before we take off. Because if you had assets, if you have family and people that depend on you, it is extremely crucial to get this sorted, and that is exactly what we're diving into today with our experienced and incredible solicitor, Patricia Galea, who will tell us about everything that we need to do before we take off and the consequences of not doing it and making sure that we have the right things in place. So if you're keen to know more, let's get straight into it. Patricia, thank you so much for joining us. So excited to have you again on the show.
Yeah, well, it's a delight all the time to be in your presence, to be able to share information with your clientele and with your friends. So thank you for having me.
That's very kind of you, Patricia. Thank you. So we spoke about estate planning and why it is important the last time we met. Today, I want to go a little deeper into it, and especially with the holiday season around the corner, people traveling, I wanted to specifically touch on why it is important and what happens if something happens to you overseas or while you're traveling, and if somebody doesn't have a will or power of attorney. That's what we'll get into today. Again, I think it's a very important topic that we should be touching on.
Absolutely, because with travel comes risk. So, and those risks can also involve severe illnesses or even death. So you need to have the appropriate documents in place so that your family can manage either your estate after you have passed, or your living estate whilst you're incapacitated.
Sure. And estate is the collection of all the assets that a person has.
Absolutely. It's everything that they own or even owe. So, of course, we all have liabilities in our life, loans, debts, mortgages. So, all of this forms part of your estate.
Okay, perfect. Yes. So, if you're traveling overseas and you do not have a will, this episode is for you. So let's start with the basics, Patricia. So if someone who is an Australian resident living in Australia, has assets in Australia, is traveling overseas, again, take my case, I travel to India, we go for a long periods of time, like 4 weeks, 6 weeks, 8 weeks. What happens to anyone who dies overseas without a will?
So, well, again, if you die overseas without a will, the representation of this in Australia is you have passed away intestate. And when you pass away intestate, it's the state laws that will apply as to how your estate will be distributed. And it may not be what you actually wish. So, for example, I have a lot of clients that, they have estranged families, or they have even children that are estranged from them. And let's say, for example, they die without a will. Well, those estranged children or family members will get a big chunk of their estate, which they may not have wanted to if they had a will in place.
Right.
So having a will in place really protect your wishes, protect what you have worked hard for, how you want to protect that, and actually dictate from the grave as to how you want that distributed.
Sure. So are we saying that the children whether they're the own children, estranged children, they become the beneficiaries of the estate by default if anything happens?
See, if there is no spouse, yes, and let's say there is a spouse or they've remarried, for example, they've remarried, so then the new spouse will get most of the estate and the children may be left out and not get anything out of the estate because we have passed intestate. Because the state laws, well, I'll take Victoria, for example, so the state law provides that the wife or the husband should get the majority of the estate. And again, so if you have remarried and you have children from past relationships, your new partner will get most of your estate and your children, your biological children, will actually be excluded.
Well, okay. So actually, this brings a very famous case. There's currently a dispute going on in India at this point, a very high profile kind of a dispute about property, about like a very rich person who passed away and he's got like 2 wives and few children from both the marriages. And again, it's not being distributed as they want it to be. The wife's taking most of it. The biological children are being left out. So the previous wife is fighting for it. So this is going on as we speak.
Oh dear, yes. And I'm dealing with some of these issues at the moment where the party that has passed away has remarried and the person with whom they have remarried has no consideration for the children of a past relationship. So then they are discarding and not even giving any personal belongings to those children. And that can become very expensive and it's also a very bitter exercise. Yes.
Sure. So basically the state will dictate what happens to it. The family will not have much of a say if something happens.
Absolutely not. The state laws will apply if you don't have a will. So this is why it's important that you feel empowered to be able to dictate how your estate will be dispensed of whilst you're in your grave.
Sure.
So, yes.
So, and the will, so if something happens, the will is a piece of document. Do we take that to who will then?
So when the person has passed, we need to apply for probate. So it's applied with the probate office here in Victoria. So when we get probate, this is the passport for the executor to actually administer the will. So the court, of course, needs the original will to be submitted to them. Then they provide you with what we call the probate, which is an authorization to the executor, allowing them to distribute the estate as per the wishes stipulated in the will.
Okay. I'll maybe take a case study of what like an average client of mine would be like a couple, husband, wife, maybe have 2 or 3 children. They have a property or maybe 2 properties. That's one under the husband's name, one under the wife's name. And if God forbid the husband passes away while they're traveling or something happened, does the property that the husband owns or under his name automatically get transferred to?
It automatically gets transferred if they are joint tenants. If they are joint tenants on title, then of course the law of survivorship will apply. It gets transferred automatically to the wife. But because the property is owned solely by the deceased, then it would depend on the size of the estate as to how much the wife is going to get out of this. Of the estate, and then if there is anything left, it gets distributed to the children. So there is a specific barem, which is 500. The first $557,000 go to the existing partner. Then whatever is left, the existing partner get half of it, and the other half the remaining half goes to the children.
And if the children are minor, that will again go back to the partner.
No, so then it will have to be kept in trust until the children are 18 years old. Which, of course, at 18, what do you know? You don't have any financial acumen. You are not armed to manage money. So, but under the law, so you are considered as an adult. So then at 18, the mom or whoever it is has to give the inheritance to the children.
But until they're 18, that money is locked away and nobody can use it.
Can't. Absolutely not. Or else it will be a wastage a wastage of inheritance, and that child at the time that they are an adult and they have, let's say, they have been victim of wastage of inheritance, then they will need to apply with the courts to get remedies.
Sounds very complicated. So this could have easily been avoided if there was a will
A
which
will in
states
place.
that if something happens to me, this goes to my partner or my children. Is that how easy?
Exactly, yes. Or or even having a testamentary trust, where assets are locked into that trust, and then there is a stream of income given to the respective beneficiaries, and that's one of the best asset protection too.
Right, okay. It sounds like it's so easy to eliminate so many problems, and if there isn't, it just becomes very complicated.
Very complicated, and what people don't understand, and why I harp on so much about it. I say, look, it is a small investment now to prevent greater wastage later down the track. So for example, I will have some people say to me, oh no, we're still young, we don't need power of attorneys, we don't need medical decision makers. I say, well, let's say that you get out of my office and you get struck by a motor vehicle and you lose capacity to make decisions. Then your decision and your family will have to go to VCAT, get a guardianship order to be able to make decisions on your behalf. So the length of time that you lose, and also the money spent on legal fees, which could have been avoided if the simple documents were in place.
Absolutely. Now, thank you for sharing that.
My pleasure.
So for someone who may have multiple assets in different countries, so again, I'll take me as an example. I probably have something in India as well. I've got some here. Can I put everything in a will?
Well, it would depend if India recognizes the will that has been drafted here in Australia. For my Indian clients, which I love serving, so I always recommend that, yes, they have a will here covering their Australian asset, but that they also appoint a lawyer in India and have a will made in India to cover the assets that they hold in India. Just to make sure that it's watertight. Yes.
And actually, I just had a question on the previous discussion that we had. If somebody has a house, the husband is under his name, he passes away, the loan as well, so it's probably mortgaged. So what happens there? What does the bank do about it?
Absolutely.
Does it write it off?
No, gosh, we wish. We wish that the bank would be that
generous
and kind and generous and write off a loan. No. And of course, what happens is your family is left to deal with a debt, and that's where you come in, of course, with all the insurances that you put in place for the families to ensure that they don't go through that financial hurdle of having to repay mortgages, of having to repay for his debts. So you have your skills to protect them, but no, the estate is still liable to pay for the debts of the deceased, including mortgages.
Okay, so are we saying that the debt, which is the mortgage, falls on the surviving partner or the surviving family members, but they may not be able to inherit the asset automatically through if there is no will in place?
Absolutely, yes.
Okay.
Because at the end of the day, the liabilities have to be paid first, and if there is not enough money in the estate to cover the liabilities, or the surviving partner does not have a borrowing capacity to refinance the loan and pay the loan off, then you're losing an asset they have to sell so they can repay the bank first and then find themselves without a roof over their head.
Right. So they'll have to refinance it under their name as well to start with.
Yes.
Right. Okay.
How tragic.
Okay, guys, it's very complicated. Please get the will sorted before you travel. Do not miss out on that. For parents traveling with kids, what is very important to have in case? Again, we spoke about properties. Children are the biggest assets that we have. How do we make sure that they are protected, looked after?
Absolutely. So this is why in your will you need to appoint a guardian. So a guardian is someone that is going to step into your shoes when you have passed to look after your children. And they have to be people that align with your values, because already you passing away, your children are going through trauma, are going through grief. You don't want them to have now a culture shock of being raised by someone that, doesn't understand your values, doesn't understand your roots. So it's important and paramount that you appoint someone that has the same vision as you for your children, and that vision has been shared with that person, and they understand how important it is that they carry your vision within your children.
So if, say, for example, somebody went overseas, the parents unfortunately passed away and the children are left behind, what happens to the children? Does some family member automatically assume the responsibility, or does any law apply here?
Applies, well, they become technically, an award of a state because you haven't appointed a guardian. So then it needs to have someone with good heart stepping up and saying, well, I will take care of his children. You can't rely on luck that this someone will just pop up and say that I am going to look after your children.
Yes.
So this is why it's paramount, it's imperative that you have those hard chats with people that are close to you, that you want to be appointing as guardians, and letting them know, look, I am giving you this role because I entrust you to look after my children. I'm giving you this role because I entrust that you will pass on my values to my children. It's also giving that importance, showing that importance to that person as to why they have been appointed.
Right. So, of course, I think that's so important to be done. But if, say, it's not done, somebody, a good friend or a family member rocked up and said, I will do it, I'll take care of it. I'm sure there are legal implications to that, and the school and everybody would need something, right?
Absolutely. Then they may have to go through an adoption process. If you legally want to adopt the children, but if you only want to become the guardian of those children, then you will have to go through VCAT. And again, it's legal fees that you are annexing to a process that could have been avoided had you had this document in place appointing guardians already.
Right. Okay. So very important again for the children.
Absolutely.
Is there any story that comes to mind when we talk about this, that something could have happened, like somebody's traveled overseas and anything happened, or is there something that you could share with us?
Absolutely. Well, just recently, we've been contacted by a young couple. They went to India to celebrate the 1 year birthday of their son. Unfortunately, their husband passed away in India after a blood clot went to his heart. So he passed away, and he also passed away without a will. So there you go. And the husband is of non-Indian background. So he's Australian, but his wife is from India. And she was so distressed, saying, I don't have any will for my husband. I don't know what he has. He has a business, I know, but I don't know what forms part of the business, or I don't know how to get his body back here in Melbourne. So she was just in a scramble because there weren't appropriate documents in place to guide her. So had he had a will, had he had an entering power of attorney or an appointment of medical treatment decision maker, all these documents in place, that would have given her the easiest key to open those doors. Those doors for her, which she didn't have at the time. But look, we assisted her. She did obtain letters of administration, but now she finds herself having to administer the estate whilst not understanding really what is part of the estate. So, and on top of that, having to bring up a 1-year-old by herself.
That's so unfortunate.
Absolutely, yes.
Right. Yeah. Again, things that can be easily be avoided. Because it has financial and emotional consequences. Like the emotional consequences sound so much bigger than the financial ones.
Absolutely. And this is what I say to people. Yes, you're trying to save, $250 here and there on those documents. And then I say, you have no idea what sort of mental peace and clarity you bring to your family members, to your decision makers when you need to be using those documents, and knowing that your voice has been expressed clearly as to what you want to achieve when you are incapacitated or when you are no longer around. That brings them a great peace of mind that you can't put money on.
Yes, 100%. Are you able to just briefly distinguish between the wills and power of attorney? Again, we've touched this, but again, if you could
Absolutely.
let us know again.
My pleasure, of course.
Thank you.
See, a will takes into effect when you have passed away. So that is prescriptive as to how you want your estate, i.e. your house, your bank accounts, superannuation, or your personal belongings. That prescribes as to how you want them to be distributed to your family members or friends. Whereas an enduring power of attorney, any medical treatment decision maker, you use them whilst you are still alive, but you don't have capacity to make financial, personal, and medical decisions. You have lost capacity because due to an accident, or you have Alzheimer, Parkinson, all of those health elements preventing you to make informed decisions. Then those documents of the entering power of attorney and the appointment of medical treatment decision maker allows those decision makers to make decisions on your behalf.
Okay.
Yes, you are dictating them as to how you want to lead the rest of your life without being able to utter those instructions.
Okay.
So it is prescribed in the document.
So the power of attorney will only come into place if something happens. Like nobody can just take over it while the person is still alive, still able to take decisions.
Nice. If he can still make decisions, if they have the ability to make informed decisions, they have all their rationality with them. No, nobody can make decisions on your behalf if you haven't lost capacity. And of course, for us as legal practitioners to enliven those documents, we always ask the decision maker to go and get a letter from a geriatrician or the doctor confirming that this person has lost capacity. Then the documents will be enlivened.
Sure. When it comes to making wills or powers of attorney, again, a lot of times people assume that they can do it online, and we've spoken about the challenges of doing it online, and it may not be the best because, again, what an expert can do, a computer cannot do.
Exactly. And I'll give you a perfect example on that. So three weeks ago, I had a family contacting me saying, well, my brother has passed away. He has left a will kit that he completed at the post office. But he didn't mention in his will as to whether he wanted to be buried or cremated. And the partner of the brother is saying, I don't want my partner to be buried. I want him to just be cremated, put in a box, and that's it. And the family, who they were quite religious, they're like, no, we want our son, our brother to be interred. We want him to have a proper religious ceremony and things like that. Well, then it was this partner against the family, trying to decipher who is actually going to have precedence. So then I had to step in and intervene and mediate the situation because the will is completely silent. And of course, the post office or the postman is not going to tell you, do you wish to be buried or cremated? You're not going to ask you the key questions.
Yes.
And had this person gone to a lawyer to do their will, those key questions would have been asked of them, and the will would have been prescriptive about it, and we wouldn't have to, whilst during our period of grief, go to lawyers and have lawyers intervene to try decipher whether the person is going to be buried or cremated, or whether they're going to have a religious ceremony or not. Well, luckily, Patricia has been able to use her niceness and her mediatory capabilities to bring the parties together, and the person has been able to be sent off, though, well, respectfully.
Okay.
Yes.
Great. That was very kind of you to do that. But again, I think it comes up more often than not. And I think it's the cost factor that most people are like, I want the cheapest option available. I can't engage a solicitor to do this. If there was someone who came with that option, is there any particular website or a place that you would recommend? Again, maybe not fully that if you wanted to really do it online, this is the place you should go to.
Well, Safe Will is quite popular. Because what I understand is that they have an AI system behind it, actually asking questions from the responses, asking further questions. So apparently it is quite extensive, the question that they ask, but how bulletproof it is, I can't tell you.
Of course.
Yes, I can't tell you. And I wouldn't even be recommending something like that to people because I know what the financial implications are if this will falls through.
Yes.
If it falls through, if it's not binding to the requirements of a valid will, then you have to spend a lot of money.
And I'd actually like to add to that creating a will is not that big of an expense either. Like some people have this misconception that it's going to cost me tens of thousands of dollars. It is not. I've done it.
Absolutely
And
not.
it is a one-time investment and it is a very reasonable investment to make.
For peace of mind, for clarity, for certainty, it is the best investment that you can do. For your family and your estate.
Exactly.
Yes.
So thank you for sharing that.
Pleasure.
What is one thing that every person should do before they're traveling?
They should have a will, an enduring power of attorney, an appointment of medical treatment decision maker to ensure that they have 360 protection for the estate.
Awesome. And they create that and they save it with you or any solicitor or?
Absolutely. So what they can also do, once the will is created, it can also be lodged with the Supreme Court, the probate office.
Okay.
And that is kept there, like it's in one fee and they save it. Or we can also keep it in our safe.
Or they can even like keep it with the accountant,
or the bank. Yes, absolutely.
Anyone.
Yes, definitely.
Okay.
But they entrust.
Okay, perfect. And what is the most common mistake that people do when they are doing their estate planning?
Oh dear. Well, one of them is excluding children from the will.
Right.
That's it. Whilst yes, you can do it, but that open your estates to be contested. That's one thing. And this is something that I see quite often these days for some reason. Yes.
Okay.
Parents coming wanting to change their will and get their children out of the will because one child is affected by drug, the other is affected by alcohol and things like that. So we don't want them to be wasting their inheritance. So, but there are ways to still implement them without having to remove them completely from the will.
Right.
Then also you have people for entering power of attorneys and medical treatment decision makers. You have people appointing decision makers from overseas. Then that becomes very problematic because if something happens to you here, how is that person going to coordinate to make decisions on your behalf? So, and you do get those families that are here and say like, look, well, here all our families are overseas. We don't have anybody. Sure, but yes, you can have somebody, you can have a friend, and you can also have your legal practitioner can also become a decision maker for you, which I would like not to. I would prefer an independent person too. But there are other ways that this can be accommodated.
Sure. Thank you for that. Can your spouse automatically make decisions for you if something happens to the person?
This is what people think. They're like, well, my spouse can make decisions for me. No, it doesn't automatically works like this because here in Australia, of course, we have a very big privacy laws, privacy issues that need to be protected and overcome. So no, it's not automatically your wife becomes your decision maker. So what they will need to do to actually be an accredited decision maker for you, as we say, is get a guardianship order from VCAT. And again, it's time and money that you are spending when you could have made a small investment when you were doing your estate planning to have that catered for.
Sure. And even the uncertainty that comes with it, because you don't know what they would.
Absolutely, you don't know what kind of decisions are going to
Yeah.
make. Well, for example, one person. Well, I had a couple last week. They were making their appointment of medical treatment decision maker, and the husband was saying, "I don't want to be resuscitated. I don't want to be placed on life support." The wife said, "No, I want you to be resuscitated. I want you to be placed on life support." So if he didn't have his documents in place and something had happened to him, the wife would have taken a decision that is contrary to what he would have wanted. So, yeah.
Thank you for sharing
My
that.
pleasure.
And again, last one, do digital copies help, or do we need the originals if something was to happen for?
Originals are always best, but you can have certified copies, so certified of the entering, power of acting, or appointment of medical treatment decision maker. But for the will, you will need the original to get probate. And if you have lost your will, then it's a whole another ball game that we need to go through to try prove your will. So it's original is always best.
Okay. And is it correct for me to say that if you're traveling overseas, make sure that you've got your wills, your powers of attorney, and your medical decision making in place? Get it done with a reputed solicitor or someone who can do it, and then save these copies with the solicitor, the accountant, someone you trust.
Absolutely. So that your key people, your key decision makers know who to access to get the documents.
Sure.
So it's important to have that transparency.
Perfect.
Yes.
Awesome. Great. And I think also getting the insurance is sorted. So don't forget that before you travel.
Insurance. Absolutely. It's a key factor that goes with your estate planning.
Yeah.
Yes.
Perfect. Sounds good. Thank you so much for sharing that, Patricia. It was a pleasure having you.
My pleasure. Always.